First case is State of Ohio versus DeShawn Stafford. Only the appellant is here for arguments. You'll have 15 minutes to present your argument. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like a child. We've read your briefs and are prepared to proceed when you are.
Judge Lanziger in the court, may it please the court. Attorney Donald Pond on behalf of the appellant, defendant appellant DeShawn Stafford. Mr. Stafford has asked me to appear here today. He opted not to have a waiver of the oral argument, even though the state has conceded error on one point of the issues that we've raised here, the two issues that we've raised. Having said that, he asked that the court remand this case upon a favorable ruling that he hopes he receives for further proceedings at the point of error, which means the case would proceed as if the plea had never occurred. The state has conceded error with respect to page 11 of the plea transcript, where the court inquires of Mr. Stafford whether he understands the implication of the plea, and then proceeds to inform him that the state has the right, has the obligation rather, to prove each and every element of the offense in the indictment. What's missing from that exchange is the specific requirement of the rules listed in the rules of criminal procedure, where the court needs to inform the offender that each and every element of the case needs to be proven beyond a reasonable doubt. I know that, and that is an error that requires no prejudice. And we don't have to show prejudice for that. So whether subjectively speaking that had a bearing on whether Mr. Stafford entered this plea is something we don't need to show. The law says he is prejudiced thereby. And
that's the point the state has conceded and says the matter ought to be remanded for that reason.
Yes, but we didn't want to take, he asked me not to take that for granted. So
understood.
Okay.
Just make sure that's the point the state concedes, that is there, period,
yes.
It should be remanded.
Yes, but they did not concede the second issue that we raised, and that is, and maybe the state in its brief for efficiency purposes, recognize that that may be enough to have this case returned to the trial court. But also the court and even counsel was confused during the plea aspect of this case, whether the indefinite sentencing scheme of Reagan-Tokes would apply where there is a major drug offender specification. And I've cited cases in my brief out of the 3rd District and the 1st District that recognizes that indefinite sentencing still applies, and that the defendant must be informed of that maximum penalty during the plea colloquy. Certainly at sentencing, the court corrected itself and recognized that the imposition of indefinite sentencing was appropriate and advised Mr. Stafford accordingly. However, at that time, the plea had already been entered. And that exchange should have occurred during the plea colloquy, which is, it's odd that the court missed that, because there's there were 3 other cases that were heard at the same time. Mr. Stafford entered pleas and a domestic violence case, a low-level felony 5 possession of cocaine case, but also another felony 1 trafficking case. And in the F1 trafficking case, where the court imposed 3 years, the court explained to Mr. Stafford that, indefinite sentencing would apply. But where there was a major drug offender specification, the court indicated that that doesn't apply and that the minimum sentence would be the maximum sentence for the felony 1, which is 11 years. So there was no discussion about the range of the indefinite sentencing that would be applied. And in fact, the plea form, the box checked on the plea form is that I understand that I am not subject to indefinite sentencing. And usually what happens is and probably without exception, is the trial attorney, defense attorney is working with the defendant to fill out this form. There's explanation there, which occurs off the record, but both counsel and the defendant have signed that form. So I think we need to take that form for what it says, is that it was explained to Mr. Stafford that he would not be subject to indefinite sentencing, and that just is not the case. So he was...
And I appreciate, number one, I appreciate you being here and not
Yes.
making an argument. So let me start out by saying that. But if we are to find that the state's correct and there was there that they've conceded on the constitutional issue, do we need to reach the statutory issue of there being a mistake? We're going to withdraw, we're going to rule the court have to be remanded, the case have to be remanded. Do we need to reach that second issue?
I don't think we need to. And but I appreciate the court recognizing that we have family members in attendance here today. They are really concerned about Mr. Stafford, and he wants a chance to try to restart this case. And I think I've laid all that out in my brief. I'm not really saying anything differently. I may be using obviously different words this morning, but I just wanted to emphasize that I believe we have 2 points of error. And if there are no questions, I would surrender the rest of my time. Thank you. Thank you. Have a good day.
Thank you for your presentation. The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also the opinion will be posted on the Ohio Supreme Court website.
Thank you.
Thank you.